Hello, my name's Stephen Gallagher, and I'm a professional consultant and professor of practice in law at the Faculty of Law at the Chinese University of Hong Kong. And this is the second in two videos which are dealing with shipwrecks, pirates, treasure hunters, and really the protection, the legal protection that's provided for underwater cultural heritage. The first video dealt with really domestic provisions, domestic laws, and linked into, of course, that an international principle to do with the law of salvage as well. So the idea was this: if you find a shipwreck, if you find treasure at the bottom of the sea, it was really dealing with the basics of how the law had developed to deal with ownership of that. And the law had developed in line with developments in technology, and we're going to see that that's true for the international regime as well. But the law had developed in line with developments in technology. General principles of the law had always been that it was based upon the law of salvage, that if you did find a shipwreck, if you did find cargo, treasure at the bottom of the sea, and you recovered it, that did not entitle you to keep it. It entitled you to a reward from the original owners or those who were successors in title. Usually that would be the insurance company who paid out for the sinking of the ship and the loss of the cargo. So it didn't mean you got to keep, correct, unless the owner could not be identified, or it could be established that the wreck had been abandoned in some way. So general principle, law of salvage applied. Now, in most jurisdictions around the world, that's now been altered to a certain extent, because most jurisdictions now have special laws which apply to what we would usually today refer to as cultural property or cultural heritage, and that usually covers their territorial waters as well, their jurisdictional waters. It usually vests any historical wreck, archaeological finds in the state itself. And the example I gave in the first video was to do with the Hong Kong Special Administrative Region of China. And of course, we have our Antiquities and Monuments Ordinance, which vests antiquities, relics in the HKSAR. Also, of course, the law of salvage, as it applies in most of these jurisdictions anyway, would say if there is wreck, which is unidentifiable, unclaimed, then again, it would usually vest in that particular jurisdiction as well, that particular state as well. So we have our domestic laws, usually based around that sort of international principle, which comes from the law merchant, the law that dealt with the seas, because of course people have been communicating across the seas and trading across the seas, well, for thousands of years. So there had to be these sort of general principles. But we have now got a development of a regime of international law, which is meant to deal with issues to do with wrecks, treasure, what today we refer to as underwater cultural heritage. So we want to discuss how that really developed. As I said, it developed in line, it always lagged behind domestic laws. Most states would develop their domestic laws before the international community, because of course getting the international community to agree on anything is almost impossible, and of course that also is why international law tends to be quite weak, even though that'll upset my colleagues who teach international law, but because you have to really cater to the lowest common denominator in getting an agreement between states. That's why when you tend to have conventions, you tend to have bits of them that are taken outside of the convention. You usually have protocols, certain bits that not everyone can agree on as well. Anyway, we'll come back to those international conventions a little bit later on, but just to say that again, as with domestic jurisdictions and the development of their law, even though international law lagged behind, it's still been driven by the developments in technology that allowed humans to actually locate, identify, recover, wreck from places that they hadn't been able to recover before. And I think it's worth mentioning at the beginning, the gentleman who probably caused most of the problems to do with shipwrecks and treasure, and that of course is Mr. Jacques Cousteau. Now again, any of you who are as old as me will remember the wonderful television programs made by Monsieur Cousteau and his family as he explored that wonderful underwater world. Well, he used his invention. He was the co-inventor of the aqualung, a scuba, a self-contained underwater breathing apparatus. And the aqualung was cheap, relatively easy to use, and allowed waters to be opened up to all of us, really, for recreational diving. It also allowed people to go searching for treasure in a way that they hadn't been able to do before, because again, it was relatively cheap, relatively easy to use this technology as well. So Monsieur Cousteau, unfortunately, probably led to a lot of the recovery of wrecks that today's archaeologists consider to be so appalling and terrible for the loss of context and knowledge about those particular wrecks. So let's talk a little bit about the developments of technology, which actually caused the international community to have concern for the loss of archaeological and historical wreck. I've put down here a number of them that I would go into in my course in more detail. Things like these huge salvage operations that were undertaken by the British of the German fleet in Scapa Flow in the 1920s and 1930s. Of course, Pearl Harbor, American ships that were sunk there needed to be raised very quickly because they were needed for the war effort by the USA. So, 1942, the Americans undertook an amazing salvage operation to recover a lot of the ships that had been sunk by the Japanese in Pearl Harbor on the 7th of December 1941. But there are other important things as well when we start to get more into the sort of the archaeological world and also the treasure hunting world. So the recovery of the wreck of the Vasa in 1961, sunk in 1628, and now, of course, in that wonderful museum, you see an incredible feat of archaeological technological skill in its recovery as well. But of course, if archaeologists can do this, treasure hunters can do that sort of thing as well, and they may not take as much care. We see the recovery of hoards like the Cayenne Beach pirate treasure hoard in 1964 by divers from the hotel there, who were the dive instructors who were in relatively shallow waters. 1971, the recovery of 35,000 silver coins from the wreck of the Hollandia, again using relatively simple diving apparatus as well. 1982, an archaeological recovery again, a huge salvage operation of the Mary Rose. 1975, we'll come back to the Nuestra Senora de Tocha in a few seconds, but those are important things. And of course, 1985, the identification of the Titanic, of the wreck of the Titanic as well. 2007, the Black Swan project. We'll talk about that a little bit later on as well, but I'd go in more detail in my course about these. This is a coin from the Hollandia, as I said, recovered in 1971. I usually include this and talk about this one because, again, it is an example of a recovery by treasure hunters. And that term, I don't use that in a disparaging way. I think, obviously, for archaeologists, they get very upset with this concept of treasure hunters. But I think we have to think of that things have changed since 1971, and we shouldn't be so disparaging to what people were up to there. I include this, by the way, because, of course, I teach my course to those who are studying law, and the gentleman who headed this particular treasure hunt was a solicitor, a London solicitor, who decided that law was too boring and went off to become a treasure hunter, which I think there's an important lesson for us all there. This is one of the most important characters in the development of the international law, and of course also his own jurisdiction, the USA's law as well. Mel Fisher, one of the most famous treasure hunters, of course, who hit really what must be termed the mother lode when he found most of the treasure from the Nuestra Senora de la Tocha in early 1970s through the 70s. It's such an important character. Again, archaeologists tend to get very upset about him as a character. But again, I think you've got to think of the context of what he was doing at the time. An enormous amount of resources went into searching for this treasure and recovering when they actually found it as well. He developed a lot of techniques that are now used by archaeologists. They probably won't like me saying that, but he did in his identification and his recovery, searching for the treasure and recover of the treasure as well. But when he did find this sort of mother lode, estimated at the time to be about $400 million US worth of gold, silver, and precious stones, Of course, there was a massive litigation at the time. You know, it's a Spanish ship. It's in US waters. He wants to claim it for himself. Lots of other people want to claim it as well. Ongoing litigation for many, many years, which eventually he wins. And that's really important because it led to the United States changing its laws, domestic laws, and it also highlighted to the international community that they possibly needed to do something. So final litigation, 1982, around that area, coincidentally, when we get our first international law, which really starts to deal with this problem of who owns wreck, who can claim wreck, who can claim the treasure that is found at the bottom of the seas. So I'm referring to the United Nations Convention on the Law of the Sea, UNCLOS, which was promulgated in 1982, came into effect in 1994. It's been referred to as a constitution for the oceans, and that's quite a nice term because it really, what UNCLOS does is it divides up the oceans. It says which bits are owned by which people. That's really what it's all about. So when we were talking about our domestic jurisdictions having their laws, well, those domestic laws would be effective within the territorial waters of states. And for coastal states, the territorial waters extend usually to about 12 nautical miles from their coast. It depends because, of course, sometimes you get coasts that are sort of touching on each other, and obviously lines have to be drawn between them as well. So there are different rules to do with this. And UNCLOS identifies this. It tells you who owns which bit of the seas, even the seabed as well, all of those things. Now, the important thing for us is that UNCLOS, shortly before it was promulgated, some changes have been brought in to put in two provisions, which were to acknowledge the importance of archaeological and historical finds at sea. They were relatively late introductions. There'd been a move from the sort of late 1960s onwards by certain states who were very worried about their underwater cultural heritage being taken to actually do something about this. Notably, Greece and Italy had been very worried. You know, these are heritage-rich countries anyway. They've had lots of problems with looting of their terrestrial sites. They were worried again because of this. The more access that people had to the relatively shallow waters of the Mediterranean or the Adriatic, that they would be able to, you know, that their shipwrecks would be found and that things would be taken as well. So they wanted some changes brought in. These are the first changes we see, though. We don't see a specific law to do with underwater cultural heritage. We see two provisions being added to UNCLOS. One is Article 303, one is Article 149. And Article 303, well, as it says there, it says that states have a duty to protect objects of this archaeological and historical nature found at sea and shall cooperate for this purpose. Now, that sounds pretty wide at sea. It does then carry on to give us a little bit more clarification. In order to control traffic in such objects, the coastal state may presume that their removal from the seabed in the zone referred to in that article, Article 33, without its approval would result in infringement within its territory or territorial sea of the laws and regulations referred to in that article. Article 33 is to do with what's termed the contiguous zone. This is the buffer zone outside a state's territorial waters. It's another 12 nautical miles. So what it really does is extends the laws that a state has, its domestic laws, to do with the protection of underwater cultural heritage within its territorial seas a further 12 miles out. That's the way it's meant to work. And so we do get an acknowledgement that there should be some form of protection. But then look at that final part. Nothing in this article affects the rights of identifiable owners. Well, okay, if you could still identify the owners, then of course the property still belongs to them. The law of salvage or other rules of admiralty or laws and practices with respect to cultural exchanges. So again, it accepts that the law of salvage would trump anyway, although in theory, the laws of the jurisdiction should extend out to the 24-mile limit at that point. Again, international laws, by their very nature, are problematic because, of course, as I said before, the idea is that you have to get the international community to agree. If you're dealing with the 220 or so states that I think are acknowledged generally around the world today, 210, 220, somewhere around there, to find agreement between a handful is often a problem. So finding agreement between all of them is really problematic as well. So these necessarily are not very strong laws. International law, the term law is always a problem with international law at times anyway. Important, again, though, as an indication of intent is Article 149, which says that archaeological and historical objects found in the area, and Article 136 tells you that the area and its resources are the common heritage of mankind. The area is the seabed under the high seas, shall be preserved or disposed of for the benefit of mankind as a whole, particular regard being paid to the preferential rights of the state or country of origin, or the state of cultural origin, or the state of historical and archaeological origin. So again, does it do very much? Not really. It's not really a law as such. It's more of a, as I said, a statement of intent. And a lot of people have looked at this provision and have criticized it. The idea of shall be preserved, disposed of, does that mean things can be recovered and sold? But, well, yeah, for the benefit of mankind as a whole, but then particular regard being to the preferential rights of the state or country of origin. It's more of an idea that we should be looking after cultural heritage, or what today we'd term cultural heritage, but it doesn't really do anything. Anyway, 1982, we get the UNCLOS being promulgated. As I said, doesn't come into effect until 1994, and it's not really going to do very much anyway, but it does at least express an idea of what the international community are thinking of. The domestic jurisdictions are at this point introducing laws, if they haven't already got them, particularly in Europe and in North America, because of these concerns, because of what's been going on with characters like Mel Fisher, and also a big shake-up for the international community, for archaeologists who were campaigning and lobbying the international community to do something to protect underwater cultural heritage, was what happened in 1985, which is when we have the discovery of this wreck. So those of you who've seen Leonardo DiCaprio's film will perhaps recognize this as the front of the Titanic. And of course, when Ballard and all announced to the world that they'd found the wreck, it was a phenomenal thing. You know, it's in the middle of the Atlantic, or very far out into the Atlantic. It's very, very deep. It's miles from its last reported position. It's a phenomenal example of the use of modern technology to identify this wreck, where it is, and then to go and explore it. And of course, afterwards, to recover items from it as well. This is one of the controversial things about the Titanic, has been that, of course, there has been salvage of items from the seabed from around the Titanic as well. So, international community, very soon after UNCLOS is promulgated, are faced with this. Wow, the technology now says that area that we're saying, well, we should have some form of protection. We might need to do something about that, because actually humans can get there now. They can find things, they can get there, they can take things away. Maybe we need to do something. An important sort of parallel event going on was the exploitation of wrecks in another part of the world, which previously hadn't attracted much attention, but suddenly did because of the discovery of an unusual form of treasure, a treasure which is no less valuable than the gold and silver that has been recovered in other wrecks, but which in many ways, it's amazing that it actually did survive. And it was the discovery of this treasure which also led to changes in one of the most influential powers in the world now, domestic laws to do with protecting cultural heritage as well. And of course, I'm referring to China there. So what was this going on in the world around about the same time that we get Mel Fisher operating in the early 80s in the United States? We get the discovery of the Titanic in 1985. We get the discovery of these great porcelain treasures. So these are the recoveries of wrecks which are laden with porcelain in Southeast Asia, around the Asia region. In particular, of course, we're talking about Chinese porcelain. Some of the great porcelain treasures have, of course, been of Chinese porcelain. And when we talk about these wrecks, we have to talk about this gentleman, Captain Mike Hatcher, probably the equivalent in Asia to Mel Fisher in the Americas. Mike Hatcher recovers a number of these incredible cargoes. Probably the first one is probably one of the most important, the 84 Hatcher cargo. It's a sort of cargo of transitional wear, very important because it filled gaps in the historical record, in the knowledge about these particular types of porcelains as well. But of course, also sells for a considerable sum at auction. So we see the recovery of this incredible cargo. It's headline news around the world. Just a year or so afterwards, he follows this up with the Geldermalsen, what's erroneously called the Nanking cargo, which of course again is sold off. We're talking about thousands of pieces of Chinese blue and white porcelain, and it attracts a lot of media attention, not least in China. And because of this, China is going to introduce laws to protect its underwater cultural heritage. So China's response, well, if we think about that period in the mid-1980s, China was in quite a strange position with regard to its cultural heritage. It had a strange relationship with its cultural heritage at that time, because of course we'd just finished with the Cultural Revolution in China, where evidence of its past, evidence of that amazing civilization, that amazing cultural past, had been destroyed, had been actively destroyed during the Cultural Revolution. But when we get to the early 1980s, we see that change in that relationship with the past, with that heritage, a recognition that China's heritage is important, its history is important, even to the Chinese Communist Party, which had previously been destroying part of its heritage. In 1982, we see the promulgation of the Law of the People's Republic of China on the protection of cultural relics. It's a general law to do with what are termed cultural relics. Again, important points, it vests ownership of any cultural relics found within China in the Chinese state. And it was quite severe in its restriction in not allowing these relics to actually leave China. Now, of course, lots of things did leave China, lots of things were smuggled out, or ways were found to get them out as well, but it was quite restrictive. It was to protect China's cultural relics, its cultural heritage. Now, shortly after this, we get all the publicity about Hatcher, the Hatcher cargo, the Nanking cargo, and we get stories coming out of China. We get stories that the Chinese government have contacted Hatcher and are asking him, can we have some examples of this porcelain? It's Chinese porcelain. These vessels could have been Chinese vessels. The Geldermalsen, of course, was a Dutch East India Company vessel, but it's Chinese porcelain. Could we have some examples for our museums? And Hatcher is meant to have said, it'd be wonderful if we ever know if he really did say this, that yes, of course you can. You just need to go to Amsterdam, go to the auction and buy some. And of course, doesn't go down very well. China did send some representatives to Amsterdam to purchase some examples. Again, the story is they just did not have enough money to buy any examples because the prices went so high. And at the same time, we see that the Dutch, because for the Geldermalsen it was a Dutch East India Company vessel, so successors in title would be the Dutch state, they received a share of the proceeds. The vessel was found in Indonesian waters, so Indonesia is meant to have received the payment. Apparently, Hatcher gave a Dutch and some Indonesian museums some examples as well, but the Chinese didn't get anything. And of course, we're talking about an auction in Amsterdam, Dutch East India Company, exploitation of China as well, with the British auctioneers, Christie's as well. So it's easy to see that this could be perceived as another form of colonial humiliation, with China being treated in this way. And it's been said a number of times, you know, the history of the protection of underwater cultural heritage in China actually began with the Geldermalsen case, with the Nanking cargo. This case forced the Chinese government to develop plans to preserve underwater cultural heritage. And I think it's a good point. What do we get? Very soon after we get this, the 1989 regulations concerning the management and protection of underwater cultural relics, which I think is one of the most restrictive protection laws that there is, that any jurisdiction has got. It's incredible in some ways in that the purports to claim control, if not ownership, over wreck of Chinese vessels or Chinese relics, even when they are outside of China's waters, even when perhaps they're in other jurisdictions' waters as well. That's something, again, that in my course we have to consider a little bit more. So its jurisdiction is, well, it's quite incredible in many ways. Enforcement of it, more difficult. And that's why I put there, you know, the idea of its effectiveness. Has it been very effective? Not really. Again, it signals intent. It hasn't really been a strong law. It's any challenges to it? Yes. 1999, we see Hatcher salvaging the Texing, which is often referred to as China's Titanic, because it was such a huge vessel. Sunk in February of 1822. We know a lot about the sinking of this because it was documented. We know the names of people who survived. We know the names of people who died on this vessel, and a huge number of people died in this tragedy as well. So when Hatcher is salvaging this, again, we've got this idea that, you know, this is a Chinese vessel. This is a Chinese cargo. It's mostly Chinese porcelain again. And China is, well, it has these laws which now purport to claim ownership of the Texing, but nothing really happens. Nothing happens there. So it's not very effective. And that's, again, an issue. But then if we think of China in the late 80s, even in the late 90s, we know that things have changed a lot since then. Since the Texing, around about the same time, we do see a little bit of change in policy. We see the Chinese government being critical of the salvage of the Texing, but not so critical of the salvage of the Belatang, the Tang wreck, as it's known, excavated around the same time. Now, my archaeologist friends will say that's because one was salvaged by Mike Hatcher and the other was salvaged by archaeologists. Hatcher sold his cargo off. So did the group who actually salvaged the Tang wreck, but that's different. And it is different. I know there are differences, but I think it's interesting that China didn't express the sort of condemnation that they had against Hatcher's recovery. And it may be because of what was happening with the Tang wreck as well, because the Tang wreck, of course, salvaged in a sort of public-private partnership with the Indonesian government and a private company. It then gets sold off to a company which is a state-controlled company, Singaporean company, and of course then the wreck ends up with all of the porcelain on display in the Asian Civilizations Museum in Singapore, which then sent on tours, which was very controversial about these tours going off around the world. In fact, lots of protest against them by archaeologists who were worried about this sort of encouraging the recovery and sale of these cargoes. But maybe why China not so vocal? Because China by this time was very aware of how important the underwater cultural heritage was in its policy objectives, and was using underwater cultural heritage very much with its policy objectives. And the Tang wreck fits very nicely, being displayed in Singapore as part of the Asian Civilization Museum. It shows that China has been trading in this sort of area peacefully for, well, 1,000 years more. So it fits very well into that narrative. And we see China realizing, actually, underwater cultural heritage fits very neatly with a message that we're trying to send to the world. So we see a lot more spending on underwater cultural heritage. We see incredible projects being undertaken to actually celebrate China's underwater cultural heritage, whether that's the inland underwater cultural heritage, in its lakes, in its reservoirs, in its dammed gorges, or at sea as well. We see the recovery of the Nanhai No. 1, an incredible feat, again, of engineering, where you don't want to dig up the wreck, as we've seen before with the Vasa or with the Mary Rose. But what you do is you just take the whole of the seabed. You take the matrix of the seabed as well and lift the whole thing. And then you excavate it in a purpose-built museum as well. Huge cost, important message. Again, this is a vessel which was a trading vessel. We've been trading for 1,000 years in this area peacefully. And it's all nice. It fits in very well with China's gentle rise. So this message works very well. A resurrection of the hero, Admiral Zheng He, celebration of the Ming voyages. Again, that idea that China's long had sort of trade in those areas. The Nanhai #1 becomes the first stop on the maritime Silk Road, and another celebration of these ancient trade links as well. So China, very much into its underwater cultural heritage, as with its cultural heritage generally, sends out a great message about the age of this great civilization, and also that message that we have peacefully traded for hundreds, if not thousands of years in areas. And if we're trading with people today, that's just because we've always traded with them. The international community, as I said, things take a long time for the international community to actually act on anything. After 82, we get the UNCLOS, we get the finding of the Titanic, we get all of these other issues going on with wrecks and disputes about wrecks being recovered and treasures being sold off and everything else. We get the reaction of the international community in 2001, where we get the Convention on the Protection of the Underwater Cultural Heritage. So this is the first purpose-designed international convention dealing with what we today call the underwater cultural heritage. It stresses how important underwater cultural heritage is to all of us because of the part it plays in the history of people's nations and their relations with each other. It's all about emphasizing that to protect it, we need to work together. There needs to be a shared responsibility. We get this stressing again that it is the underwater cultural heritage is an integral part of the cultural heritage of humanity. And then we get an explanation of what underwater cultural heritage is. All traces of human existence having a cultural, historical, or archaeological character, which have been partially or totally underwater, periodically or continuously for at least 100 years. And it gives some examples there as well. But it's interesting, it has this rolling date line. So things come to be engaged by the convention. For example, when it was promulgated in 2001, the Titanic, which had sunk in 1912, was not covered by the convention. But of course, by 2012, 2013, it's 100 years underwater. The convention purportedly covers it. We'll come back to the Titanic shortly. What does the convention do? Well, the convention stresses that there is an obligation on those who sign up to the convention to preserve underwater cultural heritage. That's all underwater cultural heritage, anything that comes within the definition, and to preserve and protect it for all. It also stresses this, and I'm going to say very shortly that I think there are problems with the convention. It stresses in situ preservation. It says, do not go and lift the wreck. Do not go and bring things from the wreck. The best way of preserving the wreck is if it's been at the bottom of the sea for hundreds of years, well, leave it at the bottom of the sea, unless it's in some form of danger. That's great. But of course, think about the wrecks that we know about. We know about these important wrecks because they have been preserved. That would mean, well, the Vassar, perhaps that shouldn't have been left at the bottom of the harbour. The Mary Rose, perhaps it should have stayed at the bottom of the sea, of the Solent. That's, I think, one of the problems, of course, with this. It should really stress, I think, that may be the first option, but it shouldn't really rule out recovering these vessels as well. It emphasizes there is no commercial exploitation. The law of salvage, it just doesn't work with underwater cultural heritage. That's the message from the convention as well. It stresses that human remains are to have special treatment. And of course, that's an important factor because with many of these wrecks that have been discovered, even after a number of hundreds of years, it's surprising that there are still human remains that are extant on the wrecks as well. So archaeologists traditionally have always been very respectful, of course, of human remains as well. And I'd like to think that those that have been termed treasure hunters would have been respectful for whatever reasons as well. But the convention does stress this: human remains are to have special treatment. It provides these rules for investigation and protection of underwater cultural heritage, cooperation to do with the protection, management, and information sharing as well. And then it puts a duty on states. In Article 18, it says, state parties shall seize underwater cultural heritage recovered inconsistently with the convention. So there's a burden on states to do this as well. If they discover that underwater cultural heritage has been recovered in a way that isn't consistent with the convention, then they should be seizing this. Obviously, the emphasis here is from private individuals, private corporations that have been recovering as well. The problems are, as I said, I think it's been considered quite restrictive, and it's also, because of this, not very effective. It provides, again, a useful aspiration, but as hard law, even though it does try to introduce probably what in international law is quite hard law, it doesn't seem to work because, well, the main reason people don't sign up to it. States have not been signing up to it. So here we see the limitations. We get this. I use the example of the Wikipedia entry for the Titanic, which says that, you know, the wreck of the Titanic falls under the scope of the 2001 UNESCO Convention on the Protection of Underwater Cultural Heritage. As I said, rolling date line, Titanic sank in 1912, so 2012, it's 100 years underwater. It comes under the scope of the 2001 Convention. This means that all states party to the convention will prohibit the pillaging, commercial exploitation, sale and dispersion of the wreck and its artifacts. Because of the location of the wreck in international waters and the lack of any exclusive jurisdiction over the wreckage area, the convention provides a state cooperation system by which states inform each other of any potential activity concerning ancient shipwreck sites like the Titanic and cooperate to prevent unscientific or unethical interventions. Great aspirations, but let's be realistic about the Titanic. Anyone going to, well, there are laws that apply to the Titanic anyway, but the original law that applied to the Titanic was the law of salvage, and the laws that applied were to do with the original investigators on the wreck and those who claimed the right to recover from the wreck as well. There have been a number of disputes here involving the wreck of the Titanic. The scope of the convention to do with the wreck, well, as I said before, the big problem is if we think of where the wreck is, in the Atlantic, and then we think about the states that are around there, particularly the traditional big maritime states, United States, Canada, Britain. If we think about the people on board and those who try and claim sort of control over the wreck, we can include France as well. We might include Ireland if we wanted to, but most of these states have not signed up to the convention, so the convention just doesn't apply. To show you sort of how unsuccessful the convention is, I just put this sort of table together. I'm focusing, of course, in Southeast Asia because being Hong Kong, that's sort of my main focus. But I've also put in, so those blue states are sort of the Southeast Asia, Asia Pacific sort of region states, the important states there that have got issues with maritime heritage, underwater cultural heritage. And then I've got these as sort of the yellow states down below, which are again, some of the traditionally considered to be some of the most important maritime states as well. So let's start with those at the bottom then. Germany, Netherlands, Portugal, Spain, United Kingdom, United States of America. 3 international conventions mentioned there. The first, United Nations Convention on the Law of the Sea, 1982. We can see that most of the states there have signed up to UNCLOS, except for United States of America. Salvage Convention, not bad, quite a few of them. Again, in the yellow states, what have we got? The only one that hasn't is Portugal, I think there hasn't signed up to that one. But then, and in the Asia Pacific sort of region, if we think of the Salvage Convention, what have we got? Hong Kong, China, Australia, India, they've all signed up to it as well. So, okay, those international conventions, UNCLOS, most popular there. The 2001 convention, out of the big sort of European, American maritime states, what have we got? Signed up to UNCLOS, Portugal and Spain. If we're looking at the Asia Pacific region, Cambodia. That means the only state whose vessels would have to be concerned about the Underwater Cultural Heritage Convention, the 2001 convention, in the Asia Pacific region would be, well, Cambodia, or vessels from Portugal and Spain who are out there as well. It's a severe limitation. As I said, international law is often aspirational. Here we can see that UNCLOS popular because it does divide up sort of ownership and control of the seas. The Salvage Convention popular because it really brings in what was a sort of an international sort of accepted behavior in the law merchant anyway. And then the 2001 convention, extremely unpopular. Still lots of questions about whether China will join this convention. If China joined the convention, we could see that that might it might act as a leader in the region, but there are problems for China joining up with the convention because of its existing underwater cultural relics laws, which are all about China claiming its heritage. And again, the convention is much more about this sort of idea of protecting for all, of safeguarding for all. So there are problems with that as well. To see some of the problems we have still ongoing in Southeast Asia with regard to REC, let me show you this sort of representation of on a map. This is the region, Southeast Asia, including, of course, Indonesia, Philippines, Malaysia, Singapore, Vietnam, Cambodia. You can see all these areas. Now we got the China just at the top there. We see that we got this huge expanse of the South China Sea. Lots of wrecks in this area. Lots of wrecks all around this area. I said to you that the most successful of the those three conventions is, of course, the United Nations Convention on the Law of the Sea, which divides up control and ownership of the seas. If we overlay the effect or the purported effect of UNCLOS onto this area, this is what we get. So this is the extent. If we go from Indonesia as its archipelago down there, the Philippines is the archipelago there, we then change and we see we get these blocks of areas where, and the hatch lines are these disputed areas which are ongoing at the moment. So of course we can see the overlaps, the issues with wrecks being found in any of these waters. It would be quite a problem. There are lots of other problems as well to do with wrecks in the Southeast Asia region, and that's, as I said, where our focus is. But there have been problems around the world to do with wreck relatively recently. In 2007, news came out about the discovery of this incredible treasure, which was termed the Black Swan Project, a recovery by Odyssey Marine. And that led to litigation, which was only solved in about 2012 or so as well. But again, it's a story you can research easily on the internet, and it's something that we go into a bit more detail on our course about that. Other issues in Southeast Asia, well, we've had this issue to do with the recovery of Second World War wrecks because well, they've been recovered with the scrap metal, and of course these are wrecks which are actually war graves. They contain the remains of those who died on them, and there's been a scandal ongoing about the recovery of these, particularly from the waters of Indonesia, and the position is probably getting worse in those waters as well. Other issues in the Asia Pacific region, pollution coming from the wrecks, the environmental damage of these wrecks as well. They've broken down, they've been under there for coming up for, what is it now, 70, 80 years underwater. Many of them had oil on board and other noxious substances, toxic substances, and these things are coming out into the water. They're poisoning the waters of the Asia Pacific region as well. And it becomes a question, who pays for this? Who actually deals with this cleanup as well? And if you want to go to markets in Asia, you will see examples of blue and white porcelain being sold, encrusted with barnacles, and you are told that it is recovered from shipwrecks as well. It obviously is being sold around Asia, so we still have the recovery of our porcelain wrecks as a problem. I'm always hopeful, by the way, that these things are fakes and not the real thing. Sometimes I'm sure they are fakes as well. Again, I have friends who say to me, it's bad if they're fakes. To a certain extent, I'd rather see people buying fakes than buying the real thing. If you have any questions about this, as I said before in the other videos, very happy to chat about any of these things by email. There's my email at the top. In my course, I deal with other issues. I'm very interested in the wreck of the SS Ventnor, which is in the waters of New Zealand, which has strong links with Hong Kong, with China, and tells an interesting story about the Chinese diaspora and the history of New Zealand as well. So it's a wreck, interesting legal issues, interesting historical issues as well, and political issues as well that we talk about on the course. We talk about the future for underwater cultural heritage. We talk about the possibilities with China's policy in the future and maybe what Hong Kong will be doing. And of course, we link all of that in with the 2001 convention and whether the 2001 convention could be more workable, I think is the best term to use. Anyway, thank you very much. As I said, very happy to hear from anyone. If you have any questions about anything that I've talked about here, or you'd like to tell me that I got something wrong. Thank you.